versus 924 Del Prado LLC. And I just got another reminder that our meeting is being live streamed on YouTube, so I want to mention that as well. And I also want to introduce the rest of the panel. We have Judge John Stargell and we have Judge Keith White with us this afternoon. Appellants counsel, how much time would you like for rebuttal?
5 minutes, please, Your Honor.
Okay, thank you. And you may begin when you're ready.
Thank you. May it please the court. Mike Brownlee here on behalf of the appellant, Cape Coral Loan Acquisitions, LLC. As Your Honors know from the briefing, my client, Cape Coral, holds 2 promissory notes that are secured by properties owned by the appellees Del Prado and Diplomat. Del Prado and Diplomat failed to pay as they were supposed to. And instead of, calling the loan, accelerating the debt, moving to foreclose, my client enters in good faith into a settlement agreement with Del Prado and Diplomat that basically lays out an alternative arrangement, sort of a path for them to be able to pay because they hadn't been able to up to that point. So,
and at the time the settlement agreement was executed, had the statute of limitations run?
It had accrued.
Expired.
It had not. No, it had not expired at that point. It was still. I think the claim would have accrued a few years before. It did not run at that point.
Okay, so the clock was ticking, but not expired.
Correct, Your Honor. So clock's ticking. They enter into the settlement agreement, and part of the settlement agreement in Section 18 says that, if this alternative arrangement does not work out, if the settlement doesn't come to fruition, and Cape Coral is forced to press its rights under the loan documents, that Del Prado and Diplomat, and I'm quoting, this is a quote from Section 18, they promise not to assert any defenses of any nature whatsoever in response to Cape Coral's attempt to enforce the loan documents.
Under the loan documents.
Pardon?
It says under the loan documents after that provision that you just stated. I was reading along with you.
It says under the loan documents or to Cape Coral's enforcement of any or all of the loan documents. So we've got a disjunctive clause there, right?
What does under the loan documents mean? What would be a defense under the loan documents?
I really don't know, Judge Wozniak. I mean, I think it could be, anything I suppose that is unique to the settlement agreement or the alternative arrangement that is being laid out. I think the upshot, and by the, including this disjunctive clause, this or to any attempt by Cape Coral to enforce the loan documents. I think the idea is, and this is buttressed by some other clauses in the agreement, the idea is that, hey, we're not forfeiting any rights we had under these original promissory notes or loan documents, right? The settlement agreement does not in any way interfere with our ability, all of our rights that we had and held originally, right? We're just trying to do something different to help these folks to pay.
So your argument is that the statute of limitations is one of these defenses that was waived, even though the word waive is not in this paragraph. So if that's the case, could your claim, your client's claims have been brought at any time? Let's say 50 years from now, 100 years from now?
That's a good question.
Is there a limit?
That's a good question. It's one I thought about quite a bit. I expected to get from you. I think the answer is yes. I mean, unless there was some other statute of frauds or something out of left field that, that some sort of, this is the wrong way to say it, but an intervening sort of independent cause. But as the loan, or as the settlement agreement reads, I think the answer is yes. I mean, I think, if you're agreeing not to assert a defense of any nature whatsoever, I don't think that gives you the right to assert a statute of limitations defense or any other type of defense, no matter how much time expires.
So, counsel, is your argument then that any defense that may have accrued after the execution of the settlement agreement, that the appellees were waiving those as well?
Correct. It's any defense. I mean, it is what the language says. I mean,
what if they fully paid the loan? Would that be waived also? Payment defense?
No,
the day after the settlement agreement, they pay the loan in full, and then nevertheless, the your clients sue. They can't raise the payment defense.
Well, that wouldn't be a defense, Your Honor. That'd be satisfaction of the loan. I mean, I don't think that's a defense. I think when you talk about defenses, you're talking about defenses to litigation, right? And a statute of limitations defense is, I think, one of the enumerated ones in the rules of civil procedure. So I mean, words matter. And if you enter into an agreement that says, we're not going to assert any defense of any nature whatsoever, you're bound by what you said. It doesn't say except for a time defense. And again, there are other sections we discuss in the briefing that buttress the idea that, a delay is not going to be held against Cape Coral. They're doing everything in their power to let these people perform and to pay on, I mean, we're talking multi-million-dollar loans here, really expensive pieces of property. And there's an agreement not to assert any defense of any nature whatsoever. And just like those Texas Supreme Court cases held that we cited in our briefing, just because a defense is all encompassing or general, it doesn't make it vague. It is what it says, which is any defenses of any nature whatsoever. So if Diplomat or Del Prado wanted to be more, specific than that, then the onus was on them to put whatever language they wanted in to the settlement agreement that would have protected their ability to bring a statute of limitations defense. But I mean, put yourself in the position of, the lawyer who's wondering about a potential statute of limitations defense. They look at this document, they say to their client, we're good. They have agreed not to assert any defenses of any nature whatsoever. That's, you've got to be able to advise a client based on plain language that's in the document. And our argument is that that language should be read for exactly what it says and should be applied as it is written.
So
I have a really basic question. Oh, Judge White, go ahead.
Well, in foreclosures, Mr. Brownlee, you'd agree foreclosure, that's an equitable proceeding, right?
Yes.
Okay. So let's say a month after the execution of the settlement agreement, the mortgagee goes to, I know there was 2 lots, one was unimproved, one was improved.
Correct.
So they go to the building on the improved lot, they burn it to the ground. That's not a defense either, I guess.
No, it's not. Words matter. You contract and you agree to things. Yes. I mean, unfortunately, and I think the cases are legion in Florida and elsewhere that say, a tough result does not allow a court to rewrite a party's contract for them. I mean, these are sophisticated business parties, right? That, had lawyers reviewing this stuff, and this is the language they chose, and it says what it says. That's our position.
But it's not as simple as just to say that there can't be defenses. There are the 2 major limitations at the beginning, correct? You've got, as long as it's in effect, and that there's no default by Cape Coral.
Correct.
So they framed the issue up front with, as long as all of these things are happening, then you can't use your defenses.
Yes, Judge Sargent, thank you for bringing that up, because it isn't important. It's not as, I suppose, as sweeping as it may sound if you read it in the abstract. You're right. It's if the agreement is in effect, if all parties are, attempting to comply, right, then you can't assert a defense. So correct. And, I don't know, Judge White, to your question, if it burned down, perhaps there's another provision of the settlement agreement that would address that, that sort of catastrophe. I don't know, but I think the onus is on the parties that are contracting to put in the language that, they feel is going to protect their interests.
I have a basic question. Under the judgment granting the final summary judgment, the trial court said that at the time the settlement agreement was signed, the defense of statute of limitations was not ripe or otherwise a known right. What does ripening of the statute of limitations mean?
I think it means that it just hadn't come, it hadn't come to fruition. It wasn't a fully formed right, but I don't think that a statute of limitations defense is ever fully formed until the last day ticks away.
Well, yeah, I guess that's my question. Does that mean expired?
I guess. I mean, I think so, which sort of defeats the purpose. I don't really know. The point is, it had accrued already. The clock was running as you discussed before, and I think the clear intent of this part of the Section 18 and other parts of the agreement were to, say, hey, we're basically a delay is not going to be held against us because we're trying something else to give these folks a chance to perform and to pay us back. And unless the court has any other questions, I think I'll reserve the rest of my time for rebuttal.
I do have one other question, Mr. Brownlee, and I noticed both trial counsel below, and I know you weren't trial counsel below, but trial counsel below and you here with us have pointed out the disjunctive in paragraph 18, meaning you have the part that talks about defenses under the loan documents, and then the broader language that you've been referring to. You know, looking at the trial court's order, I see that the trial court clearly ruled on the issue about whether the statute of limitations is a defense under the loan documents. The court specifically says that's not a defense under the loan documents. The statute of limitations is a defense as a matter of law. But what I didn't see is, where did the court actually rule on the argument that was made below and that you're making with us as far as the other part of that disjunctive waiver?
Well, I think acceptance of the interpretation that was pressed by Diplomat and Del Prado, and the rejection of the interpretation that we asked for, which was to apply the disjunctive. I mean, I think there's an implicit rejection there. I mean, I don't think the court has to say, hey, I'm recognizing this disjunctive clause and I'm, rejecting it. That was what was argued up and down to the court at the hearing and in the pleadings, in the papers. So I think it was implicitly rejected, I suppose. I think the court has read it one way, not the other.
So your argument would be that it is preserved and we can review it, even though you seem to be conceding that it wasn't an express ruling by the lower court on that issue.
Preserved, goodness, yes. I mean, it was argued up and down in the papers and at the hearing. I mean, it's as preserved can get.
But doesn't the court have to rule on, if we're going to reverse, as you're asking us to do, to reverse the judge, doesn't the judge have to make a ruling on what you're asking us to reverse on?
I think if the court is tasked with interpreting a total of like 60 words and it chooses one interpretation of those 60 words over the other side's interpretation, when it's clear what both sides are asking for, then that to me is a ruling accepting one interpretation over the other. I don't think the court has to spell out. And frankly, I think trial courts are probably too busy to say, here's exactly what this party argued. Here's exactly what this party argued. I'm adopting this party's interpretation. I mean, I could see in a more complicated scenario, perhaps, where that would be an issue, but here I don't think so. It was really, really basic what the parties were asking the court to do in terms of interpreting this section.
All right, thank you.
Thank you. And I'll reserve the remainder for rebuttal, Your Honors, unless there are any further questions.
Okay, thank you, Mr. Brownlee. Mr. Carr, you may proceed when you're ready.
Thank you, Judge Wozniak, Judge White, and Judge Starkle. Thank you for your time today. I appreciate you allowing us to appear via Zoom today. It certainly saves us a lengthy drive from down here in Punta Gorda up to visit the new 6th DCA. I am, for the record, Attorney Daryl Carr for the appellants, 920 Appellees, 924 Del Prado LLC and Diplomat LLC. I appreciate all of the questions that were recently asked of my opposing counsel. I think the distinction, and one of the things I'd like to bring up here, is the judges are well aware associated with the pertinent dates here, but I'd like to make certain that we clearly understand some of those dates and how important they are to this consideration. This settlement agreement that is under consideration here was signed in 2013, May of 2013. We're now 10 years past that point. The original complaint was filed November of 2018. There is no dispute that exceeded 5 years from the date of that settlement agreement. Therefore,
do you agree that the statute of limitations was running at the time, but it had not expired at the time the settlement agreement was executed?
I'm sorry, Judge, I don't understand your question. Do I agree?
Was the statute of limitations running? Had the clock started running at the time the settlement agreement was executed, but had it not expired at the time the settlement agreement was executed?
Yes, ma'am. Specifically within the settlement agreement, everybody agrees at that time that the loans are matured. We all understand that the Florida courts have been very specific in ruling that the maturity of a note is the start of the statute of limitations running under Chapter 95. So I believe that they were running at least as of that date, if not before. It's not disputed, however, that everybody agreed in that settlement agreement that these two notes had matured in May of 2013. I'd submit, and we could go into details, that they matured long before that, and there's certainly evidence in the record to demonstrate that. But that's really not a dispute here, because Mr. Brownlee in his brief admits that everybody agreed that the notes had matured. So we don't have any dispute that as of a date certain, May 13th, everybody agrees that the notes had fully matured. We know under the law, Chapter 95, it begins to run at that time. Had the statute of limitations ripened or come into effect then to act as a statutory bar to the litigation? The answer is no. There is that 5-year period of time that would run until May of 2018. That would be 5 years, at least from that particular date, if not earlier. So
that's what ripe means to you, the definition of statute of limitations being ripe. It's when it expires.
Well, actually, I think when it engages, in the sense that when does the statute of limitations now become a bar to the litigation? It is a ripe defense at that point, I believe, is what the court was referring to. That is, you could use it at that point, that at the time that it ripened and came be 5 years lapsed from that date, you now have the ability to raise the statutory bar to the enforcement of the documents. Is that
So if the statute of limitations was ripe, expired at the time that the settlement agreement was executed, then it could have been waived, but not otherwise.
Well, ma'am, I'd like to speak.
That's your argument?
There's nothing in this document that uses the word waive anywhere. It does say that you can't bring a certain defenses at particular times, but it never uses the word waive or iteration of that word anywhere in this particular settlement agreement. What it says is that you won't raise these defenses in defense of a particular foreclosure. What that is, Your Honor, is assuming is that these things can't be brought, is that's a breach of the settlement agreement. There is nothing in any of this documentation anywhere that uses the word waive or iteration thereof. Now, if the litigation had been commenced and if we had, in the statute of limitations had not run on the settlement agreement, then certainly they would have the ability to enforce the settlement agreement. But they do not they ask this court to construct the word waive. And I dare say that Mr. Lee, in all of his time remaining, can go through every word in that particular document and had that opportunity in both his original brief and his reply brief to show you where the word waive exists, or toll for that matter. It simply isn't in there. What he's trying to assert is something that would have constituted a breach of the settlement agreement is somehow constructed as a waiver to the defense in this matter. As this court is well aware, a statute of limitations does not arise from the agreement of the parties. It arises by virtue of the action of the state for the purposes of precluding both surprise and stale claims. What could be more stale than this particular matter that we have here? The statute of limitations is a state-created remedy that's cited to the court, the Webb versus Webb decision, and it is not it is to prevent the merits of a particular matter being considered after a period of time. Otherwise, we would have exactly what Judge, I believe, White raised is 50 years hence, Mr. Brownlee could bring this causal action. 100 years hence, there comes a time where the state says this is no longer something that you can invoke the power of the state for the purposes of enforcing. That is exactly what we have here.
Well, counsel, what's your authority for that last statement? I mean, a statute of limitations, when you say the state won't allow you to proceed, the person who, let's assume your clients have the right to raise the statute of limitations, but you just fail to do it. You file an answer, you don't assert it as an affirmative defense. Wouldn't that be a waiver, and you would then, your clients would be subject to being sued? I understand you've raised it here, but if you were silent, this case could have just kept moseying on along and gotten settled, and your clients never raised it, and it wouldn't be a bar. It doesn't divest the court of jurisdiction, does it?
I believe that a court may raise that particular issue on its own, but your first question is, what is my citation? I cited the court Webb versus Webb at 302 Southern 2nd, 1039. That's a second DCA case. Stands for the proposition that statute of limitations do not adjudicate the merits of the substantive rights, but are in essence a limitation on the availability of the remedy. And that is where we're asserting here is Mr. Brownlee and his clients are trying to assert within the court a particular remedy. What the state has done in order to preclude stale claims and surprise claims, as indicated under the Major League Baseball case, is instituted a statute of limitations that precludes the access to that remedy. The second part of your question, Judge White, is what if that wasn't raised by the defendant here? As the court is well aware from its time in practicing law, that one that doesn't respond to a litigation is obviously defaulted for the purposes of admitting all facts as well pled. It doesn't necessarily mean that they are waiving or agreeing or disagreeing the statute of limitations. They may just want that foreclosure to happen for whatever reason. But once that non-availability is raised to the trial court is obligated to follow the direction of the legislature and say, I no longer have the ability, you no longer have the availability of this remedy before this court by virtue of Florida Statute 95. If not, Judge White, hopefully if we were around in 50 years, we'd be listening to these same cases that are left over from 2010. Certainly hope the judge is around in that period of time, but it's not going to happen. The lunacy of the concept that they have for 50 years to bring these causes of action or forever simply would defy comprehension in all of the case law associated with these particular litigation. Does that respond to your question fully, Judge White?
It does.
Yes.
So I want to follow up on that, the lunacy that you suggest. I mean, if you have parties who want to continue in their agreement, they want to have an opportunity to continue their, I mean, these aren't small players, these are big boys, they know what they're doing. They want an inter agreement that says, we're going to ignore the statute of limitations so we can finish doing our business deal. They shouldn't be able to do that?
No, Your Honor. In fact, I think the case law says exactly that if you want to waive the statute of limitations, you have to do so specifically. You cannot here take language that never uses the word waive and say that, in fact, what is it we've done here is these big boys, these people that understand this complex agreement waived anything. I cited to the court, and I would reiterate that in circumstances where you are going to waive a statute of limitations is a known right that can be in fact waived and could have been waived here. But under Major League Baseball versus Marine, that has to be known at the time and specifically stated that you are waiving the statute of limitations. That simply doesn't exist here. It must be voluntarily and it must be intentional to waive the statute of limitations. Again, I dare say that there is nothing within these documents that indicate that these big players that understood what exactly they were doing back then, and understanding there's a lot of complexity under these documents that the court is unaware of. I've lived this case since actually 2016, but I can tell the court that when you look at the documentation between the parties, the word waive is never made. It's not a known right, the statute of limitations at that time, and more importantly, there is no intention in any format to say, I waive the statute of limitations associated with this matter. What Mr. Brownlee's clients did is they waited over 5 years to bring this cause of action. At that point, the statute of limitations acted as a time bar associated with this claim. If in fact he wants to say, but wait, you're breaching the settlement agreement by raising these defenses, the cause of action lies under the settlement agreement for breach of the settlement agreement. It does not allow him to direct this court to manufacture out of whole cloth the word waiver or waive anywhere in this, or the word toll, I might add, even though that's the second part of his argument and given short shrift in the first part. But that's even more convoluted there, where he wants to take disparate paragraphs in the settlement agreement and manufacture a tolling agreement out of whole cloth when the word toll isn't used at all either. If he has a cause of action or any right associated with the settlement agreement, it was his obligation to bring that as a separate cause of action, saying, wait, you have breached the settlement agreement by raising these defenses, not come to the trial court and to this court and say, wait, I want you to find waiver here. Find this word somewhere in this document, anywhere. Construe it in the broad or construe the document.
Counsel, let me ask you something. Is your argument that if the agreement says we hereby agree that we will not raise the defense of statute of limitations in any action under the loan documents or in any way affiliated with the settlement agreement, that would be insufficient because they didn't use the word waive?
No, Your Honor. I think I understood your question, but I want to make certain we're clear here. Nobody ever said we waive anything, nor did they ever say anything about statute of limitations in the settlement agreement. Do I believe that two parties can come together and have an agreement to either waive or toll the statute of limitations? Absolutely. Did that happen here? Absolutely not.
But is that because your argument is that, is your argument that in order for parties to waive the statute of limitations, the only words they can use is, I hereby waive the statute of limitations? No other combination of words would be sufficient.
Well, Your Honor, obviously, that would require me to speculate this total lexicon of the English language. However, I would note to the case, and I would point the courts to the Major League Baseball versus Morsani, the Florida Supreme Court case that deals with this. Is number one, primary purpose of the statute of limitations is to protect people from unfair surprises and stale claims. But more importantly, the very language that says statute of limitations can be waived, waiver, and this is the definition in the court, and this is under head note 2, is a voluntary and intentional relinquishment of a known right or conduct which implies voluntarily or intentional relinquishment of the known right. What we don't have here is, one, anything that demonstrates there's a voluntary, much less intentional relinquishment of a known right, meaning the statute of limitations before it had matured or ripened, whatever the phrase the court was intending to use at the trial level in its particular ruling. So I believe the Morinani case answers your question, Judge. Yes, you need to make it as a voluntary and intentional relinquishment of this known right. There is nothing within the documents upon which Mr. Brownlee's client relies upon that shows that there was a voluntary and intentional relinquishment of the known right, in this case, the statute of limitations.
I'm struggling with whether,
Go
sorry,
ahead.
was I first? I'm struggling with how the statute of limitations is not a known right at the time the settlement agreement was executed, when the statute is there and ignorance of the law is no excuse. I mean, the statute's there for everyone to read. How is it not a known right?
Well, at that time, let's assume that the litigation had been, let's assume that Mr. Brownlee's clients had proceeded timely with all of the obligations under the settlement agreement. And the court notes from the record that any number of defendants and other defendants in this matter that were also parties to this matter were dismissed as a result of either failure to serve them or because the statute of limitations was raised as a motion for summary judgment, and granted because the statute of limitations had run as to all those other parties. What we do know is in fact that they sat on all of the rights, all of them associated with this settlement agreement for over 5 years. Why would anybody do that? They were negligent, derelict, pick the phraseology, but they understood that if they ever wanted to enforce that settlement agreement, they had 5 years from the date that it was signed. They didn't do that. What we also know is that what they wanted specifically to raise a statute of limitations because nobody was anticipating. And if we look at the years, and again, allow me to find those critical dates, but if we look at the years that the settlement agreement was signed in 2013, nobody anticipated that more than 5 years later, they would file their original complaint associated with this foreclosure. That is almost impossible to comprehend. More importantly, if one looks at the settlement agreement, it actually calls on Mr. Brownlee's client to pursue certain things immediately, none of which they ever did. Did that respond to your question, Judge?
I think so. What I'm struggling with, you're telling me things, okay, they waited however long before they tried to enforce their rights, but looking at the summary judgment, it's looking back in time to the time the settlement agreement was executed and saying that at that time, the statute of limitations was not a known right. How is it not a known right when the statute's right there?
Maybe the court would, and I'm again speculating with Judge, I think it was Duryea on the lower court was thinking there. But I think what he meant is that not a known right was it hadn't lapsed, meaning the statute of limitations at that time had not lapsed. As a result, it could not have been raised as a defense. I believe that's what he was saying. That in 2013, at the time these individuals were entering into the settlement agreement, They weren't aware that the statute of limitations would be a bar to these enforcement of these promissory notes at some time in the future. In fact, it's anticipated in the particular settlement agreement that they were supposed to immediately proceed with a foreclosure against, I think it was against Del Prado, and they failed to do that. And it says right in the document, you shall proceed with a foreclosure, and they never did that until over 5 years later.
But that issue was that because of the sort of unusual, I'll call it procedural posture. I mean, your clients filed summary judgment motion before they even filed their pleading. So this issue, I understand your argument of what were they doing for 5 years. I understand that. I do have that question. I just don't know that that question is really something that we can answer at this point. I mean, the issue of the judge certainly didn't find that Mr. Brownlee's clients were in breach because they didn't do something under the settlement agreement. They waited too long or any of this. I mean, the basis for the judge's ruling is strictly based on this construction of the language before that. Isn't that correct?
I believe that is correct, Your Honor. And certainly procedurally, there's nothing relative to the procedural aspects of this case that are unusual. Recalling that they failed to file their amended complaint timely. They were 30 days delinquent. There's underlying issues associated with that and communication of what there was then the trial counsel for the other side, but he did so untimely. We waited 2 years, almost 2 years from the time that they filed the amended complaint before we filed the motion for summary judgment. That was our particular remedy at that time. Procedurally, there is nothing that requires the filing of an answer and affirmative defenses, or I might add, in this case would have been a motion to dismiss based upon the statute of limitations, because as the court's well aware, it is acceptable to file a motion to dismiss on the statute of limitations when it appears on the face of the complaint itself, prima facie in this particular case. We eschewed the procedural aspects of filing a motion to dismiss for failure to state a cause of action and simply proceeded to summary judgment because it is so blatant associated with the pleading as it exists for this particular matter. So blatant, in fact, that they don't dispute it.
Well, counsel, I'm sorry. I certainly, when I use the term unusual, I didn't mean that in a derogatory fashion, like your client hadn't followed a procedural vehicle that was available to them. I use that term because when the pleadings aren't closed, all the issues were not framed before the trial judge. Specifically, this issue of was there a breach of the settlement agreement by Mr. Brownlee's client that wasn't framed, that wasn't argued, and that wasn't before the trial court. And I was just referring to your argument where you're saying, well, Mr. Brownlee's clients were supposed to immediately do X, Y, Z, and they didn't. But the judge made no finding on it. That's what I meant. I wasn't suggesting it was improper for your clients to file their motion for summary judgment. I'm just saying in terms of, from our standpoint of what we're dealing with, there are a lot of issues that really aren't before us because they haven't been raised to the trial court. Would you agree with that?
I do, Your Honor, but please recall that the prerequisites associated with anything here in the ability to amend and bring all those issues before the trial court is they could have done it in the original complaint. They could have done it in the amended complaint, remembering it was an issue under a motion dismissed. They had 4 months from the time the motion for summary judgment was filed to the hearing where they could have moved for leave to allege all of these things associated with waiver, breach, etc. Didn't do that either. And as a result, none of that was before the trial court. And what was before the trial court was a case on its face that is barred by the statute of limitations.
It's your position under the rules that it was their burden, it was their requirement to do those things.
I'm sorry, Judge Startle.
It's your position that under the rules, then it would be their burden to have presented those things and not having to do it as a defense.
Yes, Your Honor. I think in the face of a motion for summary judgment predicated on those prima facie facts asserted in the complaint, yes, that once I establish prima facie based upon the pleadings as they exist, absolutely, this burden then shifts to them to demonstrate why summary judgment should have been granted. And they failed to do anything associated with that. I believe I'm over on my time or is that my 2-minute warning?
You are over your time. Are there any further questions from the panel? Okay, thank you. We'll go back to Thank you, Mr. Carr. We'll go back to Mr. Brownlee for rebuttal when you're ready.
Thank you. May it please the court. Okay. Starting with the whole pleading issue, there's zero support in the law for the position that Mr. Carr is espousing. The idea that you would have to plead facts in avoidance of a defense that has not been raised and in fact is never raised or pled, it is made by motion, is unsupported in the law and should be rejected out of hand. Same situation with this idea that because the word waiver isn't used specifically, I mean, walk like a duck, quack like a duck. If my kids are throwing the ball around the room, around the living room, and I come in and I say, kids, if your arm moves forward and a ball leaves your hand, you're going to be in serious trouble. And they do it again, and I come back in and they say, well, you didn't tell us not to throw it. I mean, that's not a serious argument. The title of Section 18 is no assertion of defenses. Okay. People waive constitutional rights far more important than the statute of limitations, if you even want to call that a right. For instance, you can waive your right to counsel. There's something called the Feretta inquiry in criminal courts. Happens all the time. Judge White, I know you were on the criminal bench for a long time. The idea that you would overturn a plea colloquy where someone clearly, voluntarily, and knowingly relinquishes the right to counsel because the word waive was not used in the colloquy is ludicrous. The agreement says what it says, right? It says, we agree not to assert any defenses of any nature whatsoever.
Let me just ask you on that, so make sure I'm not misunderstanding anything, because I'm late to this case, but I have reviewed everything. And what it says in paragraph 18, and tenants shall not assert any defenses of any nature whatsoever. Tenants in that clause are referring to the appellees, correct?
Sorry, no, Judge Sartle, it says 924 diplomat, each guarantor and each tenant. So I think it's providing if there's a tenant in there instead of those parties, but it definitely provides.
So Del Prado, diplomat, guarantors, and tenants, all of them together,
correct,
not assert any defense. So
right,
it's not limited to any one party or anyone else. Del Prado and diplomat, though, as the appellees here are included in that language, shall not assert any defenses of any nature whatsoever.
100%, Your Honor. And I would also encourage, so the question is, what was this a knowing and voluntary relinquishment of the right not to rely on a statute of limitations defense, in essence, to hold delay against Cape Coral? I'd point you to Section 17 of the agreement that says, neither the failure nor the delay by Cape Coral to exercise its remedies shall in any way limit or prejudice Cape Coral's rights and remedies under the loan documents.
So your position is those things read together, whatever the appellees want to call it, is an effective waiver.
Absolutely. And I think to hold that it's not a waiver makes drafting a settlement agreement or any sort of contractual document far too onerous a task. I pity the lawyer who has to be as specific as Mr. Carr is suggesting you would need to be in a document. You cannot say it any clearer, just like those Texas Supreme Court cases say, than to say we are not going to assert any defenses of any nature whatsoever. That means what it says, what it means. It's simple. Also, section.
Mr. Brownlee, let me ask you on that. And I understand your argument. And let's say for purposes of this question that I agree with your argument that to use your duck analogy, even though the word waiver is not used, the parties waived their defenses. But the question I have is applying that language prospectively. Would you agree that there is a legion of cases when it talks about waiver that there's elements existing at the time of the waiver, the actual and constructive knowledge of what right you're waiving, and an intentional relinquishment of that right? Would you agree that that's fairly common in what I'll call Hornbook law on what a waiver is?
Correct. Yeah, I would agree with that.
And so I guess help me address my concern that if you're going to waive, you don't have to convince me or persuade me that parties particularly sophisticated business people, can waive rights even if they have not accrued in the future, a right or a defense or whatever you want to call it. But my concern is, does that have to, if the law presumes that you're waiving things at the time you sign something, does the language have to be more clear than this paragraph 18 to raise a defense that has not yet ripened or accrued?
I would point you to the language that says of any nature whatsoever. And then I would also point you to the language in section 17 that talks about how a failure or delay by Cape Coral to exercise its remedies shall not limit or prejudice their rights under the agreement. I would also point you to section 25 that says neither delay nor omission by Cape Coral in exercising or enforcing its rights and remedies in connection with the loan shall be construed as a waiver by Cape Coral of any breach by Del Prado or Diplomat. This settlement agreement is wildly clear that delay shall not be held against Cape Coral. And Judge White, at the beginning of this oral argument, you raised the idea about foreclosure being an equitable consideration. That's a great point, because let's think about the equities here. We're talking about multi-million-dollar loans that Del Prado and Diplomat have not paid anything on. And they've enjoyed these properties for a really long time. And in fact, have even collected rental proceeds from a business that's running on this property. So to the extent we're going to talk about equities, my goodness, it would be a real shame. Let's not let that happen. That's an enormous windfall for a party that specifically agreed, represented by counsel, that they would never assert a defense of any nature whatsoever in response to an effort by Cape Coral to enforce its loan. That would be a really awful result for Cape Coral in this instance, and a huge windfall for parties that frankly don't deserve it because they haven't made good on their promises. And they didn't make good on their promise not to assert a defense. They shouldn't have done that. That was a breach of their promise. It's also bizarre that in no part of the summary judgment motion they filed was there even a mention of the settlement agreement, which was attached to the complaint. That's an effort to sweep it under the rug. It should not be rewarded by this court. It's an enormous windfall for them in the face of contractual language that taken together makes it very clear the parties intended for a delay not to be held against Cape Coral. That's what the trial court did. This court should reverse.
Thank you, Mr. Brownlee. Thank you to counsel, and we will be in recess.
Thank you, Your Honors.
Thank you.